All right, so we want to bring you the latest on this breaking news out of the Supreme Court. Two court decisions having to do with religious freedoms. One, the court concluded that teachers in religious schools may not have the same anti-discrimination protection laws as they are arguing they should have. And also another one having to do with businesses who have a religious objection to birth control, and it has to do with the Obamacare healthcare law. So we want to bring in Ilya Shapiro to sort of break this all down. Ilya, that's kind of like big, sweeping, single sentence explanations. But let's break it down. Can we first start with the teachers in religious schools? How did this begin? What were the arguments, and what's the conclusion of the court?
Right. So this case was filed by a couple of teachers who were fired or their contracts weren't renewed. One because she got sick and was being treated for an illness. Another, the allegation was age discrimination. And the court built on previous decisions about the so-called ministerial exemption. That is the idea that federal employment discrimination law does not apply to religious ministers. And so this case was about the scope of that, who counts as a religious minister. And so there was debate about how much religious instruction these teachers were involved in. And ultimately, the court, by a 7-2 vote, opinion by Justice Alito, the only dissenters were Justices Sotomayor and Ginsburg, found that there's a functional test. That is, if there's an element of religious instruction or vocation in what they're doing, then the ministerial exemption does apply.
That seems to me an interesting argument. If there's an element of it, I would think almost by the very nature of teaching in a religious school, having gone to Catholic school my whole life, there's always an element in almost everything to do with religious instruction. It would seem that almost anyone who worked in a religious school would find themselves unprotected. Am I misreading it?
Now, probably for teachers, but janitors or other kinds of staff at the schools probably might not be treated differently. But anyway, this is not surprising. Coming out of oral argument, it seemed like Justices Alito and Kagan were coming together on this sort of functional test for this exemption, for the ministerial exemption. And that's the reason for this, is that the court historically is hesitant to get involved in the internal administration of religious entities, religious schools, and otherwise. And so this turned out to be not, as I said, a 7-2 decision. There weren't any separate concurrences or anything, just two justices dissenting. And so basically, if it's a functional test, it's not a bright line rule, but as long as there's a significant enough involvement with religious instruction, then you receive this exemption from the employment discrimination laws.
All right, Ilya, let's go on to the other case. It has to do with employers who have a religious objection to birth control and the Affordable Care Act.
Right. So this is the ongoing saga of the Little Sisters of the Poor, a great name for a plaintiff challenging a government action. A number of years ago, the court unanimously sent back for further reconsideration the refusal to exempt them altogether or provide any sort of accommodation. Once the administration changed, the Trump administration, the Department of Health and Human Services directed an exemption from the relevant agency, and that was challenged by the state of Pennsylvania, as it happened. And here the court ruled, well, it was complicated. It's kind of a 7-2 ultimately to vacate and reverse the ruling, but for further discussion below about exactly whether the agencies jumped through all the right hoops. But on almost every issue that the lower court ruled, the Little Sisters ended up winning. That is, that the agencies do have the power in crafting their regulations about who to whom the Obamacare contraceptive mandate applies. They can exempt these kinds of institutions, but now the court says basically the lower courts will have to look at whether the agencies went through the proper processes in doing so. And there was a concurrence by Justices Thomas and Gorsuch saying, look, this litigation has gone on long enough. We should just say that end it right now rather than put it for further proceedings. But again, the only two dissenting justices were Ginsburg and Sotomayor. Kagan and Breyer concurred and said that, well, we're not sure whether they went through the proper channels and all that. But again, that's not our call to make at this time.
I apologize if I'm asking you to kind of like go through the crates of Supreme Court decisions, but the Hobby Lobby case, was it similar to this case?
Somewhat. This Hobby Lobby involved a for-profit company, and Obamacare's regulations never exempted any for-profit companies of any kind, whether they claim to have religious exercise claims or otherwise. And so that decision said that because of the Religious Freedom Restoration Act, a federal statute, that to achieve the goal of providing low-cost contraceptives and other such medical devices, the government could use other ways by providing government clinics or tax credits or what have you. They don't have to impose this burden on the Hobby Lobby company. After that, the nonprofits were treated differently because within the Obamacare contraceptive mandate, there were certain kinds of exemptions for churches and houses of worship. For other kinds of religious organizations like the Little Sisters of the Poor and other organizations that were not churches, they're social service organizations or other charitable groups, there was a complicated scheme that they had to accomplish to get the exemption. The Little Sisters objected to filling out certain kind of paperwork. They felt it was part of being complicit in the sin that they ultimately objected to. So this is a more complicated administrative technical challenge to regulations that were, where were the regulations that granted certain kinds of accommodations, were they too onerous in themselves? And I apologize for kind of making it, very technical, but that's what this is about. This is not a constitutional challenge about the free exercise. This is about the minutia of the regulations. And as the court described today, whether the agencies jump through the proper hoops in promulgating these exemptions.
Okay, what are we still waiting for from the Supreme Court? What big decisions?
Right. So the two Trump tax cases, that is subpoenas from the House Judiciary Committee and from the Manhattan District Attorney about the president's tax returns. Those are different cases because congressional power is different than the power of a grand jury. And whether Oklahoma is constitutional, as we discussed the other day, where about half of the state of Oklahoma is potentially still an Indian reservation, the way that the treaties worked and potentially were not abrogated. But either way, all of those cases, those are the three remaining cases, the two Trump tax cases, the Oklahoma case, will be released tomorrow at 10 a.m. We will know. That's the last day for the court this term. All right, then it's a date, Ilya. We'll see you tomorrow, hopefully. Thanks. Good to see you, Anne Marie.